This is Barry Zalma, Zalma on Insurance. Today, we speak about Zalma's Insurance Fraud Letter, Volume 25, Issue 16, for August 15, 2021. Today's issue deals with a case where a claim for damages to property that existed before the issuance of the policy was determined to be fraud, since it is a crime to claim pre-existing damage as new damage. After accepting a plea agreement, the defendant, of course, has no right to expunge his criminal record, although Vsevolod Sergee Garanin appealed from the order entered in the Court of Common Pleas of Lackawanna County, denying his expungement petition in a case called Commonwealth of Pennsylvania versus Garanin in the Superior Court of Pennsylvania, and decided on July 30, 2021. On April 4, 2016, Garanin purchased an UltraPac insurance policy from Erie Insurance Group for a 4-unit rental property on Ripple Street in Scranton, Pennsylvania. The policy became effective beginning April 4, 2016. Subsequently, on October 14, 2016, Garanin submitted an insurance claim for 4 freeze-damaged boilers at the insured property, and Erie Insurance Group generated a claim. Garanin claimed that the boilers were damaged by sub-freezing temperatures that occurred in April of 2016. On November 1, 2016, inspection revealed that the freezing damage to the boilers occurred prior to or during March of 2016. Before the issuance of the policy. Moreover, Garanin's handyman and plumber confirmed the boilers were in the building in March of 2016, and that when he tried to fire them, they were cracked and damaged. Garanin willingly made this fraudulent insurance claim with misleading support to obtain a loss payment of $35,800. for damages that occurred before his insurance policy was in effect. On June 7, 2017, the Commonwealth of Pennsylvania charged Garanin with 3 third-degree felonies: theft by deception, false impression, theft by deception, failure to correct, and insurance fraud. On May 17, 2018, the Commonwealth's attorney sent a letter to defense counsel formalizing a final offer of a plea to criminal attempt theft by deception, failure to correct, a first-degree misdemeanor, in exchange for Garanin's promise to 1. Pay $20,000 to the Northeastern Pennsylvania Insurance Fraud Task Force, withdraw any and all civil lawsuits against the Scranton Housing Authority, perform 20 hours of community service in Lackawanna County prior to his sentence date, and dissolve his corporation, Yucca Prop 2 LLC. The Commonwealth's offer letter stated that in addition, the Commonwealth will be willing to drop all other charges not listed herein. On June 6, 2018, pursuant to the proffered plea agreement, the Commonwealth dismissed 2 of the 3 charges. Furthermore, the Commonwealth amended the remaining charge to a first-degree misdemeanor, grading wherein Garanin entered a guilty plea to criminal attempt theft by deception, failure to correct. On January 8, 2019, after a thorough review of the pre-sentence investigation report and sentencing guidelines, Garanin's history and characteristics, and the underlying nature of Garanin's offense, the trial judge sentenced Garanin to the restrictive intermediate punishment program for a 4-year probationary period, including 3 months of incarceration. 3 months Lackawanna County house arrest program, pay restitution to Erie Insurance Group for the amount of $5,413, and refrain from the use of drugs and alcohol. Thereafter, on June 25, 2019, Garanin filed a petition to expunge, requesting to fully expunge arrests and other court records pertaining to the 2 nolle prosts, or will not prosecute, charges of theft by deception, false impression, and insurance fraud. The Pennsylvania Supreme Court set forth the well-settled appellate standard of review for a court's grant or denial of a petition to expunge a criminal arrest record, that the decision to grant or deny a petition to expunge rests within the sound discretion of the trial court, and appellate courts review that court's decision only for abuse of discretion. When a prosecution has been terminated without conviction or acquittal for reasons such as nolle pros of the charges or the defendant's successful completion of an accelerated rehabilitative disposition program, then the Pennsylvania Supreme Court has required the trial court to balance the individual's right to be free from the harm attendant to maintenance of the arrest record against the Commonwealth's interest in preserving such records. However, a court of appeal has distinguished those cases where the prosecution has nolle pros charges against the defendant from cases in which charges were dropped pursuant to a plea agreement. In those cases where charges are dropped or dismissed pursuant to a plea agreement, expungence is inappropriate because it obscures the true circumstances under which the defendant was convicted. The trial court found that the charges were actually dropped or dismissed pursuant to the plea agreement because the Commonwealth never conceded that it lacked the necessary evidence to proceed on the felony charges. It is axiomatic that the Commonwealth's decision to drop charges pursuant to a plea agreement carries no implicit admission that proof is lacking. Rather, that decision is simply part of a bargain with the defendant to avoid a trial in exchange for a plea to lesser charges. Such a bargain is quasi-contractual. If the court then expunged the dismissed charges, the court would have no accurate record of the contractual relationship entered into by appellant and the Commonwealth. In the absence of an agreement as to expungement, the appellant stands to receive more than he bargained for. Garanin's case is sufficiently distinguishable from his claimed authorities, and a remand for evidentiary hearing is unnecessary according to the appellate court. Garanin's guilty plea is of record, as is a recitation of the plea agreement by virtue of the special prosecutor's final plea offer letter. The appellate court concluded, therefore, that Garanin's felony charges were dropped pursuant to a plea agreement. Based upon the prosecutor's statements to the court, there was no agreement as to expungement. The use of the word drop in the plea offer letter, the lack of a Rule 585 order or nolle pros request in the record, and the fact that Garanin did not file a habeas corpus petition. In the opinion of Zalma's insurance fraud letter, Mr. Garanin was lucky. The plea agreement offered to him eliminated the need to go to trial over a 5-year felony of insurance fraud where the evidence against him was overwhelming, and he only had to serve 30 days in jail. He tried to clear his record by a motion to expunge instead of thanking the prosecutors for their kindness to him. His insult appropriately failed. Fraud is a serious crime, and it should be prosecuted vigorously rather than charge or change it to a misdemeanor to avoid the need to go to trial. Prosecutors should all be ready and willing to try every case they bring. Garanin avoided trial and 5 years in prison, and then insulted the court system by trying expungement, failed, and then took the issue up on appeal, only to properly fail again. The issue also contains a man bites dog story where Geico gets an injunction against medical providers who allegedly filed fraudulent arbitrations. In that case, the plaintiffs, Geico, sued Alexandr Zaitsev, MD, and many other healthcare providers for aiding and abetting and unjust enrichment and violation of the New Jersey Insurance Fraud Prevention Act. Additionally, Geico sought a declaratory judgment that the defendants may not recover on any of the outstanding bills submitted to Geico. In Government Employees Insurance Company versus Zaitsev et al., filed in the U.S. District Court for the Eastern District of New York, the USDC dealt with Geico's motion for a preliminary injunction to stay all of the defendants' pending no-fault insurance collection arbitrations against Geico and to enjoin the defendants from commencing any new no-fault insurance collection arbitration litigation against Geico. The court found that the balance of hardships favored Geico. First, all the parties will benefit from having the issue of fraudulent incorporation determined in one action. Granting the stay and injunction will actually save all parties time and resources. Rather than adjudicating hundreds of individual claims in a piecemeal fashion, all claims can be efficiently and effectively dealt with in a single declaratory judgment action. Furthermore, defendants will not be disadvantaged if the stay is granted, since they will be entitled to statutory interest on their unpaid claims, should they ultimately prevail. The district court agreed with Geico that the requested injunctions will not cause defendants any prejudice at all. Geico undoubtedly has the ability to pay if the defendants prevail. Geico's motion for a preliminary injunction was granted, and the defendants' pending arbitrations were stayed. Insurance fraud, of course, is estimated by the industry to take between $80 and $300 billion every year from the industry. Insurance companies are mandated by insurance fraud acts and regulations to work to defeat insurance fraud. Geico, unable to get assistance from the state, was proactive against healthcare providers who it believes are attempting to defraud it. By filing a RICO action and obtaining an injunction against the healthcare providers, it is hitting them where it hurts, in their pocketbooks. If they succeed, they will take the profit out of fraud. If Geico doesn't succeed, they'll pay the claims. If they succeed, the local prosecutors should consider criminal prosecution of each of the healthcare providers named by Geico in this injunction suit. In addition, Zalma's insurance fraud letter reports on convictions from the Coalition Against Insurance Fraud, a report that about how fraud is created by some less than honorable legal professionals, an article on health insurance fraud convictions, starting with that of Dr. Richard Davidson, a chiropractor who pled guilty to Medicare fraud and now owes $10.7 million to the federal government. A report on the estimated cost of fraud in Europe in 2017, with a report from InsuranceEurope.com, revealing that insurance fraud is just as effective in the European Union as it is in the United States, and reports on free insurance videos from Zalma on insurance, and a report of other than health insurance fraud convictions, listing multiple convictions, including that of an ex-West Virginia mayor who pleaded guilty to stealing flood relief funds, and how a title company is required to pay $1 million in penalties after its employee broke the law to protect some of his real estate customers, and information about new books and books available from the insurance claims library published on my site, www.zalma.com. Thank you for your attention. This video is just a small taste of the August 15, 2021 issue of Zalma's Insurance Fraud Letter. It and the August 1 issue is available at my website by clicking on the link to Zalma's Insurance Fraud Letter. Please pass this video on to your colleagues. It's free, and please refer them to Zalma's Insurance Fraud Letter so that they can learn more about how to defeat insurance fraud. Thank you again for your attention.